Hello friends, welcome back to the series of lectures. This is the 38th lecture of the series of Indian Evidence Act. And we have to look upon the character evidence from section 52 to 55. First of all, you have to understand what is meant by the character. Now, what is meant by character? Character is the virtues of a person. Virtues मतलब qualities. Qualities में we have good qualities or bad qualities. Both. If it is a good quality, then a good character, and if it is a bad quality, then it is a bad character. Now, whenever a wrong is committed, suppose B has committed a breach of contract. Now, here the point is, apart from other relevant facts, one more fact can be examined. One more fact can be examined that can be do the breach of contract. Now, I am not saying that it must be examined. I am saying that it may be examined. That look at the character of B, that he may do the breach of contract. That he is a person of bad character, and he may do the breach of contract, or that he is a person of good character, and therefore a breach of contract cannot be expected from him. Similarly, suppose A is an accused of having committed an offense, for example, an offense of section 354 of IPC, that is outraging the modesty of a woman. Now here, apart from the other relevant facts, you may also examine the character of A. Is A of a bad character? Bad character means what? That is it possible that he may commit such an offense? Or if he is of a good character, then it is not possible that he may commit that kind of offense. So character to some extent may throw a light upon the possibility of a person committing that wrong, or the impossibility of that person committing wrong, or the impossibility of the person committing that wrong. So similarly here also the character is suggesting that B is the person. Character will suggest whether B is a person has committed a breach of contract, or B is a person which not committed a breach of contract. For that purpose you will examine his character. अब किसी व्यक्ति का कैरेक्टर कैसे देखोगे आप? How will you examine the character of a person? अब किसी व्यक्ति का कैरेक्टर आप कैसे देखोगे? How will you examine the character of a person? Suppose you have to prove the character of a person, good or bad, then how will you prove the character of that person? You can prove it by his previous conduct. उसने पहले क्या क्या एक्ट कर रखा है. Suppose B may have done a breach of contract at several occasions in the past. Then it means what? Means he is a person of bad character, and he may commit a breach of contract. Previous conduct से related एक और term है some similar occurrences. Means earlier also he was indulged in such a kind of activities. Or you can prove his good character or bad character by the opinion of people about him. That opinion what is called reputation. The opinion of people about him, that is what is called reputation. Similarly, you can prove his good character or bad character by his dispositions towards others. By his dispositions towards others. That is how he behaves towards others. अब रेपुटेशन का मतलब है दूसरे लोग उसके बारे में क्या समझते हैं, दूसरों के मन में उसके बारे में क्या ओपिनियन है. दैट इज रेपुटेशन. एंड डिस्पोजिशन इज हिज कंडक्ट टुवर्ड्स द अदर्स. सो आपका दूसरों के प्रति आचरण, योर टेम्परामेंट यू कैन से, और योर एटीट्यूड टुवर्ड्स अदर्स. योर टेम्परामेंट और योर एटीट्यूड टुवर्ड्स अदर्स, एंड दिस विल टेल बाय द पीपल. पीपल विल टेल. आपसे थोड़ी पूछा जाएगा दैट व्हाट इज योर एटीट्यूड. For this, people will be asked. A person from the public will be asked that what is your opinion about disposition of a person. Then he will say that his disposition is good or bad. Similarly, people will be asked what is your opinion about him. Then the people will say that he is a person of good reputation or bad. So these are some examples by which you can prove the character of a person, a good character or bad character. अब किसी व्यक्ति का रेपुटेशन जो समाज में वो कैसे बनेगा? By his conduct only. If I do the good conduct towards the others, so I will having the good reputation in the mind of the others. If I do the bad conduct to the others, then I will having a bad reputation in the mind of the others. Similarly, how the opinion of disposition is found, that is also by conduct. If I am behaving well with the others, then disposition is good, and so on. Means your individual actions will be there. Means जो आपका रेपुटेशन या डिस्पोजिशन बनेगा लोगों के मन में, वो आपके आचरणों की वजह से बनेगा. आपने कभी कोई ऐसा आचरण किया होगा जो कि सामान्य आचरण नहीं है, बुरा आचरण है. उस घटना की वजह से आपके मन में मेरा बैड रेपुटेशन बन गया, ओपिनियन ऑफ बैड डिस्पोजिशन बन गया. लेकिन अगर हमारा आचरण अच्छा है, मेरा आचरण अच्छा है, कोई ऐसी घटना हुई जिससे आपको मेरा आचरण अच्छा लगा, then that is a case of good reputation. So what I want to tell you is that your behavior, your individual behavior, that is instances of your individual behavior, instances of your conduct of a person, that will create a good reputation and a opinion of good disposition in the minds of the others. Now you see section 55 का explanation, that they are saying section 52, 53, 54 and 55 the words character includes both reputation and disposition. The word character includes both reputation and disposition. Means if you know about the character of a person, then you will examine reputation and disposition as well. But they are saying includes. Includes means what? It means it can be other things also. For example, previous conduct, similar occurrences, etc. They will also be the basis of forming opinion about your character. But they are saying includes means reputation and disposition भी आपके character का part माना जाएगा, character का part भी माना जाएगा. मीन्स और भी चीजें हो सकती हैं, रेपुटेशन एंड डिस्पोजिशन एक पार्ट है. सेक्शन 52 till 55 the word character includes both reputation and disposition, but except as provided in section 54, evidence may be given only of general reputation and general disposition and not of particular acts by which reputation or disposition were shown. So this is what you have to understand, where evidences may be given only of general reputation and general disposition and not of particular acts, general instances by which reputation or disposition were shown. अब मान लो फॉर एग्जाम्पल किसी एक केस में कोई एक्यूज्ड है ए, उसके ऊपर चार्ज है फॉर थेफ्ट. देयर इज एन एक्यूज्ड ए एंड ही इज हैविंग चार्ज of committing theft. A के ऊपर charge है that he has committed theft. Now here the defense wants to prove the good character of the accused and prosecution wants to prove the bad character. And good character is relevant. Good character in criminal matters is relevant. It is relevant in section 53. Now what will the defense prove for proving the good character of the accused? Maybe he will prove his previous conduct, maybe other occurrences in the past. It can also get witnesses in order to prove the reputation or disposition of the person. Reputation and disposition is also the part of the character. अब मान लो मुझे witness बनाकर बुलाया regarding the good character of a person, and they asked me that in your opinion, what is the reputation of this person? Then if I say that in my opinion he is having a good reputation, he cannot commit this kind of offense or act. So that much is sufficient. Now suppose if they ask me that on what basis you are saying that, then I will say that he does lot of charity. He is distributing money to the needy peoples. I had seen him to giving him money to a poor man. I had seen him to giving dresses to poor people. So these are various instances because of which I found my opinion that he has got a good reputation. He is a good person. What this explanation is saying is that I can give my opinion. I can give evidence of my opinion that in my opinion he has got a good reputation. But I will not be allowed to give evidences of the individual instances on the basis of which I have formed my opinion. जो मैंने कपड़े और रुपयों के एग्जाम्पल दिया था, that he is helping people buy clothes or money, that I cannot say into the court. I simply has to say that in my opinion he is a nice person, he got a good reputation. That's it. अब on what basis I am saying, that basis I will not allowed to reveal in the court. That is what the explanation says. Similarly, suppose I am called to prove his disposition. Suppose A के ऊपर चार्ज है कि उसने B के साथ मारपीट किया था. He had fought with B and he has caused hurt to B. अब A के ऊपर suppose charge is 323 का. अब I am called as a witness to prove his disposition. अब in court when I stand, I will simply say that in my opinion, A got a good disposition towards the others. But I am not allowed to reveal on what basis. अब हो सकता है maybe I have seen some instances upon which I have believed he is having good disposition. वो जो individual instances है जिनके basis पर मैंने जो opinion बनाया disposition का, वो individual instances का मैं evidences नहीं दूंगा, सिर्फ मैं अपना opinion बताऊंगा that in my opinion he has got a disposition, good disposition or bad disposition. That's it. Now similarly, 5-10 people brought into the court. These are the people from the society and they will all give the opinion that he is of a good disposition. तो वो बताएंगे disposition good है इसका या bad है. लेकिन जब विटनेस बयान देगा तो उससे ये नहीं पूछा जाएगा कि तुम किस घटना के आधार पर ये कह रहे हो कि उसका रेपुटेशन अच्छा है या खराब है. When the witness gives the testimony in the court regarding the reputation or disposition, then the witness will not be asked to reveal the incident on the basis of which he is declaring that he is getting a good reputation or disposition or bad reputation or disposition. So that is what this explanation clarifies. See the explanation once again. They are saying the word character includes both reputation and disposition. I say that includes means there are some other words also. There may be some other evidences also. But reputation and disposition is also an evidence of character, good or bad character. The word character includes both reputation and disposition, but except as provided in section 54. 54 पढ़ेंगे हम देखेंगे उसमें क्या है. Except as provided in section 54, evidence may be given only of general reputation. General reputation means what? If I am the accused and you have to prove my good character, then the evidence can be given of my general reputation. General reputation means certain people from the society. 2-3 people from your society, 2-3 people from your house or village, 2-3 people from your area where you are studying or you are working, 2-3 people from neighbors. So these 5-10 people are called and the opinion is given. They all will stand in the court one by one and say that I hope that he has got a good reputation. And when they will say that I am having a opinion of good reputation about him, and these are the people, these are the different people from the society, and when they stand in the court and tell that in my opinion he is a great person or good person, that means what? That becomes a evidence of general reputation I have into the society, and general opinion and disposition, reputation or disposition into the society I have. So that is what they are saying, may be given only of general reputation. जनरल मीन्स क्या? लोगों के मन में उसका रेपुटेशन, एक व्यक्ति के मन में नहीं, एक व्यक्ति के मन में नहीं, जनरल पब्लिक. Be given only of general reputation and general disposition, and not of a particular acts by which reputation or disposition were shown. Means the individual acts because of which I have got the reputation, that individual act will not be proved into the court. Simply the people will stand into the court and say that in my opinion he is a good person, or in my opinion he is a bad person. Why you think that I am a bad person? That instances you do not have to prove into the court, or you do not have to show those instances into the court because of which you form such opinion. Now take down some points. Write down points. Character of a person is his qualities or virtues, good or bad, that is his attributes which may render means which will make it possible, that he may commit a wrong, or that he may not commit a wrong, The past conduct or the indulgence of the accused or the defendant in similar instances in the past may be evidence of his character. At the same time, the reputation of the person or the opinion of others about his disposition is also an evidence of his character. The next sentence. If good or bad character of the party concerned, is relevant, then the witnesses of reputation and disposition can be produced in the court. Such witnesses will give the evidence of their own view about the reputation or disposition of the person. Own view about the reputation and disposition of the person. While giving the evidence, as per the explanation, the witness will not be required to state the specific incidents on the basis of which he formed that opinion about the reputation or disposition. As per explanation of section 55, the witness will not be required to state the specific incidents on the basis of which he formed that opinion about the reputation or disposition. For example, if the witness has formed a bad opinion about the disposition of the person because he saw him quarreling with some other person, then in the evidence he will state only that in his opinion that party is a person of bad disposition, but he will not state that he thinks so because he saw him quarreling with some other person. मान लो आपने ए को किसी से झगड़ा करते देखा और उस झगड़े करते देखा, इस वजह से आपने एक ओपिनियन बना दिया कि दैट ही इज अ पर्सन ऑफ बैड टेम्परामेंट, बैड डिस्पोजिशन. अब दैट पर्सन इज एन accused in a case and you are called for giving the evidence into the court, evidence of as to whether he is a person of bad character or not, and you stand to the court and give the testimony that in my opinion this person has got a bad disposition. Bad disposition means bad temperament towards the others. Only that much you have to say. Why you believe so and what is the incident you make that opinion. All that you do not have to state into the court. Now you give the evidence. Now you may be cross examined. अब क्रॉस एग्जामिनेशन में आपसे ये सवाल नहीं पूछा जाएगा आप ऐसा क्यों सोचते हो, और उसके बाद दूसरा विटनेस आएगा वो भी बताएगा अपना ओपिनियन, एक और विटनेस आएगा वो बयान देगा। मान लो ऐसे 5-6 पर्सन्स आ गए और जो उसके कैरेक्टर को लेकर डिस्पोजिशन को लेकर बयान देते हैं दैट ही इज ऑफ बैड कैरेक्टर और नॉट हैविंग गुड डिस्पोजिशन, देन ऑब्वियसली द कोर्ट विल फॉर्म इट्स ओपिनियन। अब ऑब्वियसली कोर्ट हैज टू see that there should be some neutral persons who is giving the opinions. I hope you understand that what is meant by character and character evidence. अब देखो सेक्शन 52 एंड 55, 52 से 55 के बीच में जो सेक्शंस हैं इसमें से 52 एंड 55, सेक्शन 52 एंड 55 they are related to character of a person in civil cases. Section 52 and 55 they are related to character of a person in civil cases, and section 53 and 54 they are related to character of a person in criminal cases. Now first we have to complete the civil cases wala part, then we will see the criminal cases wala part. Now let's see section 52. In civil cases, the fact that the character of any person concerned is such as to render probable or improbable any conduct imputed to him is irrelevant except in so far as such character appears from facts otherwise relevant. In civil cases, the fact that the character of any person concerned is such as to render probable or improbable any conduct imputed to him is irrelevant. मतलब सिविल केसेस में गुड और बैड कैरेक्टर ऑफ द पार्टी इज इररेलेवेंट. सो द स्ट्रेट फॉरवर्ड द पॉइंट इज कि सिविल सूट्स में आप गुड या बैड कैरेक्टर का एविडेंस नहीं दे सकते बिकॉज दैट इज इररेलेवेंट एक्सेप्ट इन सो फार एज सच कैरेक्टर अपीयर्स फ्रॉम फैक्ट्स अदरवाइज रेलिवेंट. अब देखिए मान लो किसी सिविल केस में एक पार्टी का बैड कैरेक्टर या गुड कैरेक्टर, तो पहले बैड कैरेक्टर की बात कर लेते हैं. किसी एक केस में किसी पार्टी का बैड कैरेक्टर फैक्ट इन इशू कैन बी ए फैक्ट इन इशू. अगर फैक्ट इन इशू है बैड कैरेक्टर तो इसको सेक्शन 52 से कोई मतलब नहीं है, क्योंकि सेक्शन 52 सिर्फ ये कह रहा है कि गुड या बैड कैरेक्टर विल बी इररेलेवेंट. But here we are not talking about irrelevant. It is about fact in issue. What I am trying to tell you is that in civil suit, the good or bad character of a party is irrelevant. That is fine. But it may be directly a fact in issue. And in that case, obviously the party concerned will prove the bad character. अगर irrelevant है तब आप प्रूव नहीं कर सकते, that is fine. लेकिन अगर डायरेक्टली फैक्ट इन इशू है तब तो कोई रेस्ट्रिक्शन नहीं होगा, क्योंकि ये सेक्शन है रेलिवेंसी पर. कैरेक्टर इज नॉट रेलिवेंट, दैट इज फाइन. बट इफ द कैरेक्टर इज डायरेक्टली a fact in issue, then the bar of section 52 will not apply. If the character is directly a fact in issue, then the bar of section 52 will not apply because it is a fact in issue. Then obviously the party concerned has to prove that fact. For this, let's see an example. Suppose A has defamed B. A ने B के बारे में कुछ publication किया. A had made some publication about B. Simply A says that B is of a bad character. इतना ही बोल दिया उसने किसी को. मान लो A ने किसी C के सामने बोल दिया कि B is a person of bad character. अब that is a defamation. अब किसी के बारे में कि वो बैड कैरेक्टर का, ये कैसे बोल सकते हो आप? ए ने लोगों के सामने बोल दिया कि दैट बी इज ए पर्सन ऑफ बैड कैरेक्टर. अब B files a suit against A claiming damages for defamation, that A has said about me that I am a person of bad character, and for this I need damages. इसके लिए B ने सूट फाइल किया. अब if you have read tort of defamation, तो here A का कहना है that it is true. अब tort of defamation में the publication of truth is a complete defense. Truth का publication is a complete defense. अब A का इधर कहना है कि whatever I have published is true. जो कुछ मैंने publish किया that is true and therefore I am not liable to pay any damages. Because defamation में true publication is always a good defense. True publication is always a good defense in defamation case. अब मान लो कोई व्यक्ति चोर है और वो कन्विक्ट हो चुका है पहले 2-3 बार. He is a thief. अब मैंने उसके बारे में बोल दिया कि वह व्यक्ति चोर है. अब he files a suit against me for damages for defamation. Then in this situation I can always take the defense that it is a true publication and I will prove that he has convicted several times. अब here A says that it is true. अब आप बताइए that the fact that he is a bad character person, वो इस केस में fact in issue होगा कि नहीं? होगा, क्योंकि fact in issue क्या होता है? Anything which determines the right or liability. Any fact which establish the right, liability, etc. अब suppose A proves that he is actually a bad character person, so the proof of that bad character person is not going to be a complete defense for A, and this will go on to refuse him to give any kind of liability, and therefore the bad character of B is not a relevant fact, but it is directly a fact in issue. Why? Because here that will give a complete defense to A if proved. अब यहाँ पर A अगर B का बैड कैरेक्टर प्रूव कर देता है तो मीन्स उसने फैक्ट इन इशू प्रूव कर दिया और उसको कंप्लीट डिफेंस मिल जाएगा. तो क्या वो बैड कैरेक्टर का एविडेंस दे सकता है? वो समाज के लोगों को बुलाकर उसका रेपुटेशन प्रूव करवा दे, उसका प्रीवियस कंडक्ट प्रूव कर दे, जैसे भी. he can always give the evidence of bad character. Section 52 will not apply as a restriction here because section 52 is only talking about relevant facts and not about fact in issue, and therefore if the bad character of a person or the good character of a person is directly a fact in issue in the case, then section 52 will not restrict that and such bad or good character can be proved. अब इसको लिख लीजिएगा, write down. Section 52 relates only to the relevant facts and therefore it will not apply in the cases where the character directly is a fact in issue. For example, as above, the bad character of B, if proved, will give complete defense to A. Bad character, if proved, will give complete defense to A from the tort of defamation. And therefore, bad character here is directly a fact in issue, and the prohibition of section 52 will not apply here, and the prohibition of section 52 will not apply here, and A can give evidences to prove the bad character of B. ये पहला पार्ट था. इधर सेक्शन से मतलब नहीं है क्योंकि सेक्शन सिर्फ रेलिवेंसी की बात कर रहा है. The first point to tell you was that bad character or good character, if it is in fact in issue, then it will not fall in these sections. This section is only about relevant facts and not about fact in issue directly. फिर से पढ़ो अगर in civil cases the fact that the character of any person concerned is such as to render probable or improbable any conduct imputed to him. So that is direct declaration. Any conduct imputed to him is irrelevant. So that is direct declaration. अब किसी सिविल सूट में डिफेंडेंट का या प्लेंटिफ का गुड कैरेक्टर या बैड कैरेक्टर, अब जैसे बी हैज़ कमिटेड अ ब्रीच अगेंस्ट ए, breach of contract. He has filed suit against B. अब B wants to prove his own good character. B, the defendant, wants to prove his own good character. He wants to prove that I am not the person who it is probable that commit a breach of contract. So he wants to prove it is improbable that I would commit a breach of contract because I have got a good character. And he wants to give the evidence of good character so as to prove that it is improbable that I may have committed a breach of contract. Then would it be allowed? जब तक वो कैरेक्टर, आंसर इज जब तक वो कैरेक्टर डायरेक्टली फैक्ट इन इशू नहीं होगा तब तक एज ए रेलिवेंट फैक्ट आप उसको प्रूव नहीं कर सकते. इसको भी आप लिख लीजिए. एज पर सेक्शन 52 गुड और बैड कैरेक्टर ऑफ एनी पार्टी. एनी पार्टी में प्लेंटिफ और डिफेंडेंट दोनों आएगा. एज पर सेक्शन 52 गुड और बैड कैरेक्टर ऑफ एनी पार्टी इन अ सिविल सूट is irrelevant. In a civil suit is irrelevant to prove the conduct included upon him to be probable or improbable, and therefore the party concerned cannot directly give evidence to prove good or bad character in the suit. Cannot directly give evidence to prove good or bad character in the suit. मतलब अगर आप चाहते हो कि मैं अपोजिट पार्टी का बैड कैरेक्टर प्रूव कर दूं या फिर ये प्रूव कर दूं कि इट इज़ हाईली प्रोबेबल दैट ही हैज़ कमिटेड अ रॉन्ग, देन यू कैन नॉट गिव एविडेंस ऑफ दैट. एंड इफ यू वांट टू प्रूव योर ओन गुड कैरेक्टर टू प्रूव दैट इट इज़ इम्प्रॉबेबल दैट आई मे हैव कमिटेड अ रॉन्ग, दैट ऑल्सो यू कैन नॉट प्रूव. फिर से पढ़ो एक बार. In civil cases, the fact that the character of any person concerned is such as to render probable or improbable any conduct imputed to him is irrelevant, except insofar as such character appears from facts otherwise relevant. अब ये लास्ट पार्ट है इसका. What do you mean by except insofar as such character appears from facts otherwise relevant? थोड़ा ध्यान से समझिएगा इसको. उस सूट में अगर एक पार्टी ये कहता है कि मुझे डायरेक्टली गुड या बैड कैरेक्टर का एविडेंस देना है तो वो नहीं दे सकता क्योंकि गुड या बैड कैरेक्टर अपने आप में रेलिवेंट नहीं है. लेकिन मान लो उस सूट में एक पार्टी कहता है कि मुझे अपोजिट पार्टी का प्रीवियस बैड कंडक्ट प्रूव करना है. मुझे अपोजिट पार्टी का प्रीवियस बैड कंडक्ट प्रूव करना है. तो सेक्शन 8 में रेलिवेंट है कि नहीं कंडक्ट. If he wants to prove bad conduct, previous conduct of the other party, then that is relevant under section 8. So section 52 will not control section 8, section 10 or other section etc. Section 52 only controls what is there in section 52. और section 52 कहता है कि good and bad character is not relevant. You know by the virtue of section 136 that is if something is not relevant, evidence will not be allowed on that. And here it is clearly said that the bad character or good character of a party is not relevant. Means as per section 136, if you want to give the evidence of good or bad character of party directly, then that will not be allowed. Then it is inadmissible. Lekin if you want to give the evidence of the conduct of the party, or if you want to give the evidence of the similar occurrences is relevant under section 14. If you want to give the evidences of similar occurrences, then obviously similar occurrences is relevant under section 14 and no one can stop you. If you want to give the evidences of conduct, then that is relevant under section 8. You cannot be stopped from that. Now suppose if you prove the conduct of a person, or suppose you prove a similar occurrence कि इसी व्यक्ति ने पहले भी इतनी बार ब्रीच ऑफ कॉन्ट्रैक्ट किया है, इसी व्यक्ति ने पहले भी नेग्लिजेंटली टॉर्ट किया है कई लोगों के साथ, वो सिमिलर ऑकरेंसेस अगर आप प्रूव करते हो और वो सिमिलर ऑकरेंस के प्रूव होने से अगर कोर्ट इन्फ्रेंस निकाल लेता है दैट दिस पर्सन इज ऑफ ए बैड कैरेक्टर, आपने प्रीवियस कंडक्ट प्रूव किया अपोजिट पार्टी ने, विच ही कैन डू बिकॉज प्रीवियस कंडक्ट इज रेलिवेंट, and breaches of the previous conduct or conducts which are being proved or which have been proved, the court draw an inference that this person is of a bad character, then that bad character is not irrelevant. Then that bad character is not irrelevant. Bad character will be irrelevant only when you want to give a direct evidence, and that will not be allowed. Evidence upon that will not be allowed. But if you give the evidence upon some other relevant facts, and from that other relevant facts the inference of bad character is inferred, then character is not irrelevant. Means then it is relevant. If you see the language very carefully, in civil cases, the fact that the character of any person concerned is such as to render probable or improbable any conduct, probable or improbable, any conduct imputed to him is irrelevant. अब उसके आगे लिखते हैं एक्सेप्ट, मीन्स आगे वाले फ्रेज में जो फॉल करेगा दैट वुड बी रेलिवेंट. यहाँ लिखते हैं इज इररेलिवेंट, फिर आगे क्या लिखते हैं एक्सेप्ट इन सो फार एज सच कैरेक्टर अपीयर्स फ्रॉम फैक्ट्स अदरवाइज रेलिवेंट. मतलब कैरेक्टर रेलिवेंट भी होगा सिविल केसेस में, लेकिन कब? जब वो कैरेक्टर किसी और रेलिवेंट फैक्ट से इन्फर किया गया है. लेकिन अगर आप डायरेक्टली कैरेक्टर का एविडेंस देना चाहते हो उस केस में कैरेक्टर इज इररेलिवेंट. सो कैरेक्टर विल बी रेलिवेंट when he did not give a direct evidence of character. He gave evidence of some other fact, section 8, section 14, etc. And from those facts you have proved the character, good or bad, is inferable, can be inferred. Then in such case character will be relevant, but not otherwise. इसको लिख लीजिए आप. In civil cases, what section 52 declares is that good or bad character of a party is irrelevant. However, in the same section it is declared that the above rule will not apply in those cases wherein the character is proved not by direct evidence but it can be inferred, bracket में appears, it can be inferred from the evidence proved regarding some other relevant fact. Thus, if a party wants to give evidence directly of the bad character of the opposite party or his own good character, then it will not be allowed. However, if the same party wants to prove the previous conduct or similar occurrences regarding the opposite party, then since these facts are relevant respectively under section 8 and section 14, previous conduct section 8 में आएगा और similar occurrence section 14 में आएगा. Since these facts are relevant respectively under section 8 and section 14, evidence on such fact will be allowed. However, upon the proof of these facts, the character of the party also may be manifest, visible. The character of the party also be manifest or can be inferred by the court. Such character which is thus inferred from other relevant facts. Such character which is thus inferred from other relevant facts will not be hit by section 52 and will be relevant. Will not be hit by section 52 and will be relevant. तो पॉइंट क्या है आप समझ गए होंगे। पॉइंट ये है कि अगर किसी व्यक्ति का अगर आपको कैरेक्टर प्रूव करना हो तो आप क्या क्या प्रूव कर सकते हैं। आप किसी विटनेस को बुलाओ, उसके रेपुटेशन या डिस्पोजिशन का बयान करवाओ। You get the witness and make him prove to the reputation or disposition, and in this case it will be said that you are directly producing evidence for character. But if you get a witness to prove the previous conduct, or you get a witness to prove the similar occurrences, then no doubt these two are evidences of character also. But are they not relevant in some other sections also? So you are producing these evidences not because of section 52 or these sections. You are producing these evidences because of section 8 and section 14 respectively. So section 52 will not restrict section 8 or section 14. So if you want to give character evidence, though it is not allowed here, so it is better to give evidence of previous conduct or similar occurrences which will be allowed, and if from that the character is inferable, then that character is relevant. But if you want to give direct evidence in the form of reputation or disposition, then that reputation or disposition is not relevant in any other section, and therefore that relevancy is in section 52 and section 52 prohibits, and therefore directly अगर आप reputation और disposition का एविडेंस दोगे सिविल सूट में, देन इट विल नॉट बी अलाउड, क्योंकि 52 इसको प्रोहिबिट करेगा। सिमिलरली अगर आप प्रीवियस कंडक्ट प्रूव करते हो, बेशक आपका हिडन एजेंडा ये है कि आप कैरेक्टर प्रूव कर दूं, लेकिन रेलिवेंट तो सेक्शन 8 में है, तो आप अगर प्रीवियस कंडक्ट प्रूव करते हो तो सेक्शन 52 आपको बार नहीं करेगा, और उसी को क्लैरिफाई करने के लिए लिखा है except in so far as such character appears from facts otherwise relevant. The fact which is not relevant in section 52 but it is relevant elsewhere. जैसे conduct is relevant, similar occurrence is relevant. अब उसको प्रूव करने से if character is also proved, then that character is not hit by section 52. So that is all for section 52. अब इसको रिवाइज करिएगा आप very carefully. Now come to section 55. In civil cases, the fact that the character of any person is such as to affect the amount of damages which he ought to receive is relevant. वैसे तो section 52 में they have said that the character is not relevant, but here they are saying that in the suit where they are claiming damages, the character of the plaintiff, because who ought to receive the damages? The plaintiff. So the character of the plaintiff is relevant if it affects the quantum of damages. Character of the plaintiff will be relevant if it affects the quantum of damages. In civil cases, the fact that the character of any person is such as to affect the amount of damages which he ought to receive is relevant. अब suppose A has filed a suit against B. A has filed a suit against B and A is claiming damages. What they are saying in 55 is that if the character of A is such as it will affect the quantum of damages that he ought to receive, if the character of A is such as would affect the quantum of damages which A ought to receive, then what? Then the character would be relevant. Now take an example in this. Suppose H promised W to marry her. H ने promise किया था that I will marry you, and thereafter H commits a breach. Now the W files a suit against H. W files a suit against H claiming damages. Now in civil suits the character is not relevant. तो H और W का character relevant नहीं होगा unless it appears from some other relevant facts. ये तो 52 कहता है हमारा. But what 55 says this: if the character of W is such as it affects the quantum of damages as C would, as what C ought to receive. If the character of W is such as would affect the quantum of damages what C ought to receive, then the character will be relevant. सूट के कॉज ऑफ एक्शन को डिसाइड करने में कैरेक्टर रेलिवेंट नहीं होगा माइंड यू, क्योंकि सेक्शन 52 डायरेक्टली प्रोहिबिट कर रहा है। लेकिन कॉज ऑफ एक्शन डिसाइड हो जाए उसके बाद जब डैमेजेस की बात आएगी, डैमेजेस का क्वांटम डिसाइड करने में कैरेक्टर तब रेलिवेंट होगा जब कैरेक्टर W का है और W को जो डैमेजेस मिलेगा, जब डैमेजेस मिलेगा दैट वुड बी अफेक्टेड बिकॉज ऑफ हर कैरेक्टर। बट इन द ओरिजिनल सूट इन द कॉज ऑफ एक्शन कैरेक्टर इज नॉट रेलिवेंट एज पर सेक्शन 52। अब सपोज दिस W, you remember I told you that W will get damages for the mental trauma, for societal stigma, everything. But suppose if it is proved that W is a woman of bad character. When I am using the word bad character, then don't take it in the sense of जो कि हम normal common language में use करते हैं, that this woman is of bad character, वैसे नहीं बोल रहे हैं यहाँ पर। bad character मतलब कुछ ऐसा past है उसका, या फिर कुछ उसने ऐसा किया है जिसकी वजह से एच ने अपना प्रॉमिस तोड़ दिया। सपोज इफ इट इज प्रूव्ड दैट आफ्टर द प्रॉमिस मेड बाय एच डब्ल्यू वाज गोइंग अराउंड विथ सम अदर मैन which H came to know, and then H asked her to not to do this, and then also she did not stop. अब यहाँ पर H ने प्रॉमिस तो कर दिया कि that I will marry you, but here it is W's fault. She was going around with some other person, and she is very intimate with that person, and H came to know about it, and he asked to not to go with him, but she refused. So is it not therefore H broke the promise? तो H promise broke करेगा तो damages तो देगा, लेकिन क्योंकि W की खुद की भी गलती है, W का कैरेक्टर यहाँ पर रेलिवेंट है, her previous bad character through her relationship with some other person if it is proved, and therefore the quantum of damages will be reduced. Quantum of damages can be reduced. So that is one example to prove how this can be relevant. अब ये point याद रखना आप, if W is entitled to take damages because of the breach of contract of marriage, but W herself committed the mistake, her own character was not good because she was going along with some other person which H asked not to do, and still she refused. So here the bad character of W will result into the reduction of the quantum of damages. अब इसमें एक पॉइंट लिख लीजिए आप, सेक्शन 55 makes the character relevant only to the extent of calculation of damages. 55 make the character relevant only to the extent of calculation of damages in favor of the plaintiff. The character only of the plaintiff will be relevant under section 55 and not of the defendant. However, the character is relevant only with respect to the quantum of damages and not with respect to the cause of action. मतलब cause of action के लिए character relevant नहीं होगा, damages के लिए character relevant होगा, वो भी किसका कैरेक्टर, प्लेंटिफ का कैरेक्टर। अब इसको आप 12 से रिलेट करो। 12 क्या कहता है, एनी फैक्ट विच हेल्प्स इन डिटर्मिनिंग द क्वांटम ऑफ डैमेजेस इन अ सिविल सूट विल बी रेलिवेंट। सो देयर अ क्वेश्चन अरोज, विल द कैरेक्टर ऑफ अ प्लेंटिफ और डिफेंडेंट also be relevant in determining the damages? The answer is the character of the plaintiff will be relevant if it affects the quantum of damages, but the character of defendant will not be relevant because there is a general bar upon character की relevancy under section 52. यही तो लिंक किया था हमने section 12 से। section 12 कहता है that any fact which determines the quantum of damages will be relevant. Now, there are so many things. Similarly, the question was, if the character of plaintiff and that of the defendant also be relevant in determining the quantum of damages. For that, the final answer in civil suit we have is that there is general bar under section 52, and therefore the character will not be relevant unless it appears from some other relevant facts. It will therefore not be relevant even in the calculations of quantum of damages. But 55 is a specific provision which says that in calculation of quantum of damages, the plaintiff character will be relevant. Impliedly, therefore, the defendant character will not be relevant. इसको भी लिख लो आप. Section 12. Section 12 declares that, write down. Section 12 declares that any fact which helps in determination of quantum of damages will be relevant in a civil suit. Therefore, under Section 12, even the character of plaintiff and defendant should be relevant. However, Section 52 puts a bar upon such relevancy, and therefore character of either of the parties should not be relevant in the civil suit, either for deciding upon the cause of action or for deciding upon the quantum of damages. Nevertheless, under Section 55, the character of plaintiff has been declared to be relevant for the purpose of deciding the quantum of damages. Thus, character would be relevant only to the extent and defendant's character will not be relevant. Now, this is all about what? Civil cases. अब इसमें एक और एग्जांपल देख लेते हैं. सपोज ए files a suit against B. B files a B done a counter claim against A. Now in counter claim A becomes the defendant. Now is it not in the counter claim the defendant's character would be relevant? क्योंकि counter claim के लिए B would be considered a plaintiff, but practically B is the defendant. अब here B का character तो relevant होगा by virtue of section 55. So is it not practically that the defendant's character become relevant? The answer is no, because here B's character is relevant because in counterclaim B is considered to be a plaintiff. B's character will be relevant here in the counterclaim because B, for the purpose of counterclaim, is considered to be a plaintiff. So that is for civil matters. Next we have to see character in criminal matters. That we would continue in the next lecture. That's it for this lecture. Thank you for watching lecture.